Patents and trademarks, which are types of intellectual property law. A patent is a form of intellectual property law that grants the right to use, produce, and sell a certain process, machine, article of manufacture, or composition of matter. So patents are not automatically granted like copyright, but an application must be submitted. And the work must also be original. So you cannot patent something that already exists. Non-obvious. So it cannot be too obviously already something that could be easily conceived. So for example, a pencil holding table does not qualify, although I didn't think that a pencil holding table is that obvious, but that's the example you see out there. And as you can imagine, there's a lot of debate on what is non-obvious. And useful. So there must be some material purpose to the item itself. And here I have a picture of the toilet paper, which apparently was patented by a person named Seth Wheeler in 1891. And if it was patented, then it must have been original, non-obvious, and useful. It's clearly useful. If it was original, I wonder what people were using before 1891. And obvious, I guess it's so ingrained in our minds that it seems non-obvious, but I guess it seemed non-obvious to those that created. And interestingly, he was from Albany, New York, where I lived for many years. Patent. So there's two kinds of patents. Utility patents, which applies up to process, machine, article of manufacture, or composition of matter. So these are the more kind of functional aspects of items and creations. In the US, these patents currently last 20 years. And design patents, which are more to the ornamental or shape of a functional item. Remember, it's still about kind of useful item. And this is also called industrial design right or registered design. In US, these patents currently last 15 years. As you may be aware, there are a lot of fights and arguments over patent infringement. A big one is between Samsung and Apple. So one company says they stole their feature of this and that, and the other company retorts and say that they were the ones who stole this other feature. And interestingly, these are kind of very simple things like distinguishing between single touch and multi-touch gestures. Okay, or just enlarging documents by tapping the screen. So you tap the screen, the document enlarges. So apparently one of them had patented that, and then the other one also used it, and then they claimed that it was their unique invention and they should be monetarily compensated for that. After, I don't know, more than maybe 10 years or almost that amount of money in legal suits, they apparently settled, but I'm not sure if they're still in case against each other. The issue, I think, more problematic is when we take this intellectual property concept, which is of course useful, but when we take it, which is ad absurdum, to the absurdity, ad absurdum, we take it to the extent where we are patenting things like seeds, animals, or other genetic material that essentially gives companies the right to create life and then the possession to own other people. In a way, we're kind of creating a new form of slavery over the genetic material of animals, of seeds, and potentially human beings as well. So we need to keep an eye for that. And these are some of the major issues nowadays regarding patent and intellectual property. Trademark is the last intellectual property we're going to discuss, perhaps a little bit more simpler, and it's a type of intellectual property law that grants the exclusive right of use to a word, sign, design, or expression that enables products or services to be identified as coming from a particular source. It is supposed to help consumers so that not everyone can sell a Nike shoe or an Apple Watch or use the same kind of propaganda that they use, such as "I'm loving it" or "just do it," right? So there's these kind of words like Nike has, "just do it," and somehow they can trademark that, even though it's a common or at least reasonable English phrase. So maybe granted via common law, which is automatically granted like copyright, or it can be also registered via an application. Trademarks, unlike patents or copyrights, do not expire, which is interesting too. And I wonder what the rationale is for that. I don't know, to be honest, but probably a little bit nefarious. So if you have a company and you sell chocolate and you call yourself M&M's chocolate, of course, you don't want somebody else to call themselves M&M's, and you can distinguish it by call it S&M's, and maybe you can get away with that. If a company already trademarks the term Colgate, you can make yourself a better one and call your toothpaste Coolgate, but you cannot call it Colgate. But Coolgate is definitely, it sounds much cooler, so better for you. Facebook is already trademarked, but you can establish somewhere a place called Face Food, and that's not trademarked. So there's always a way around things, and that's a beautiful thing. Next, we'll talk about software license and terms of use agreements.